No, sir, but I would like to go pro se, and I would like a fast and speedy jury trial. I ain't killed nobody in the board. You say murder. You say murder arrangement.
That's what that paper said. I don't know. I was just going off what my paper said.
I know me and the officer got the fighting in ISP. I know they ain't killed no motherfucker. Ain't no motherfucker in lockup. I just came from lockup at ISP. And I know you can't possibly have the battery, try to charge me no battery on staff. He assaulted me with a handcuff, and he used it as if they were some brass knuckles and hit me in the mouth with it. You can't charge me with battery on staff. I don't do shit like that. He battered me. What time is it? 12:30 yet?
It's 11:30.
Oh yeah, it's that time. It's 20. Yeah, it's 11:26. I thought you said murder out of hell car. Wow, I was happy. What the victim at? Shit, what the motherfucker ever did say? Shit, I'm 100 pounds. The officer I got to fighting with, this motherfucker was like 6'4". Shit, about 300 pounds. African dude. I'm an American African. You hear me? I'm an Irish African. You see, he from Africa. He a real African. They have no idea the evidence that I got. This is in retaliation because I filed a lawsuit already against this. I'm upstairs working on it right now to file to the federal court. I gotta go back and look that up. That's like that's retaliation or something. And officer, by law, it's Indiana law. If you create your own injury, I'm not responsible for doing it to you. You hear me? That's Indiana law. So I don't know why there's a prosecutor up over here at the court over here wasting his time. I ain't pleading guilty to a damn thing. You gotta take me to trial. Got to. I ain't pleading guilty to no motherfucking battery. This got to be the battery because we got to fight in that ISP. Officer tried to bully me. I mean, that's what I'm here. That's what I'm here for. They already punished me. They gave me SIG time. You know what I'm saying?
Okay, can you hear me, sir?
Yes, sir, I can hear you. How you doing today, Judge?
I'm doing well. How are you doing, sir?
I'm doing okay.
All right. This is State of Indiana versus Jonathan McPherson. Where are you currently housed, sir?
I'm at Westville Correctional Facility, WCU, the lockup unit.
Okay, thank you, sir. Sir, have you received a copy of that charging information yet?
No, sir.
We're going to make sure we get you a copy of that. We'll send it to you, okay?
Yes, sir.
Do you have any questions about the rights that I have advised you of today?
No, sir, but I would like to go pro se, and I would like a fast and speedy jury trial.
We'll get to that in just a second, okay?
Yes, sir.
All right, please pay attention. The State of Indiana is going to read you what the charging information says, and then they're going to tell you what the possible penalties can be.
Yes, sir.
Mr. McPherson, the charging information includes 3 counts and reads as follows. On October 8th of 2025 in LaPorte County, state of Indiana, Jonathan McPherson, while acting with the intent to commit the crime of murder, did strike Officer Prince Boating with a deadly weapon in the head, which conduct constituted a substantial step toward the crime of murder, which is to knowingly kill another human being. This is a level 1 felony. Level 1 felonies are punishable between 20 and 40 years in the Indiana Department of Corrections with an advisory sentence of 30 years and a fine of up to $10,000. For count 2, on or about October 8th of 2025 in LaPorte County, state of Indiana, Jonathan McPherson did knowingly or intentionally inflict injury on a person that creates a substantial risk of death or causes serious permanent disfigurement, specifically by striking Officer Prince Boating with a deadly weapon in the head. This is a level 3 felony, punishable between 3 and 16 years in the Indiana Department of Corrections, with an advisory sentence of 9 years and a fine of up to $10,000. And for the final count, on October 8th, 2025, in LaPorte County, state of Indiana, Jonathan McPherson, while incarcerated in a penal facility, specifically the Indiana State Prison, did knowingly or intentionally possess a device that is intended to be used in a manner that is readily capable of causing bodily injury, specifically sock with a lock contained inside of it, and the device is a deadly weapon. This is a level 4 felony, punishable between 2 and 12 years, with an advisory sentence of 6 years and a fine of up to $10,000.
Sir, do you understand what the charges and allegations are against you?
Yes, sir, I do.
And do you understand what the possible penalties can be?
Yes, sir.
Right. So what is your current out date?
2051.
Okay. You are asking to have a fast and speedy trial, and you're asking to represent yourself. Let me ask you this. Did you want to have a consultation with an attorney before you do that? Or do you want to represent yourself from the get-go?
I would like to represent myself from the get-go.
All right. So let me ask, I got to go through some things with you and ask you some questions just to make sure that you're able to represent yourself and that you and I are both comfortable with that. Are you under the influence of any drugs or alcohol as we talk today?
No, sir.
All right. You've indicated you want to represent yourself at trial, and you have that right to do that. Before we make a final decision on that, I want you to understand some things that you'll be giving up. You may have any number of defenses that can be raised and can be pursued, which an attorney would be trained to know. Should you be convicted of the offenses that are listed herein, you know you're facing a lot of time in prison. Do you understand that?
Yeah, Judge. Yes, sir.
Okay. You understand that if you represent yourself and the case doesn't turn out the way you want, you're not going to be able to complain that you did not have an effective attorney, so that one complaint or that one issue on post-conviction is taken away from you because you have agreed to represent yourself. Do you understand that?
Yes,
You're
sir.
not going to be able to go back and say, well, if I'd have had an attorney, things would be different. So now I want to appeal or I want some post-conviction relief. Do you understand what I'm saying?
I really don't, but
So there's certain things you can say and appeal after trial. Not having an attorney is not going to be one of those because you agreed to represent yourself. Do you understand that?
how about I ask for an attorney?
You can't come back and say, we're going to do over because I didn't get an attorney.
I would request an attorney, Judge.
You would like one?
Yes, sir.
Okay. Then what we're going to do is set this over. What do we have for April 24th at 9 a.m. for status? You'll be here in court with your attorney. So at any time, if you decide, hey, I think I want to represent myself, you'll have this conversation again, and then we will let you do that. But I really prefer you talk to an attorney before you do that. See if you get a good vibe with your attorney and things go well. We have a very experienced attorney that represent people in this court. They're not brand new. They've been doing it for 20 plus years, and they're pretty good at what they do. Okay.
Yes, sir.